Absolutely. Here's a look at those key emerging principles within India's environmental law, including their history and judicial treatment. A. Polluter pays principle. Background. Emerged internationally within the OECD in the 1970s, gaining worldwide importance after the 1992 Rio Declaration. Principle meaning, requires those who cause pollution to bear the financial burden of preventing, controlling, and cleaning up environmental damage. Judicial approach in India. Oleum gas leak case, first mentioned in this case, paving the way for future recognition. Indian Council for Enviro-Legal Action vs. Union of India, 1996, explicitly endorsed the principle, establishing its firm place in Indian legal thought. Subsequent cases, courts apply the principle for cleanup liabilities, compensation to victims, and directing industries to invest in pollution mitigation. B. Precautionary principle. Background. Formulated in the 1970s with significant attention due to the Rio Declaration. Its intent is proactive decision-making in the face of scientific uncertainty surrounding environmental risks. Principle meaning, if actions might cause serious or irreversible environmental damage, taking protective measures shouldn't be postponed due to insufficient scientific proof. Judicial approach in India. Vellore Citizens Welfare Forum vs. Union of India, 1996, the Supreme Court adopted the principle, establishing a basis for preventive decision-making. A. P. Pollution Control Board vs. Prof. M. V. Naidu, 1999, Court highlighted that even with uncertain outcomes, environmental threats warrant protective measures. Subsequent use. It informs court judgments in evaluating risks from industries, development projects, and GMOs. C. Public Trust Doctrine. Background. Has roots in Roman law, the idea that certain natural resources should be held in trust for the public good. Principle meaning, the government acts as a trustee, duty-bound to safeguard and nurture vital natural resources like rivers, forests, and the coastline for the benefit of present and future generations. Judicial approach in India. M.C. Mehta vs. Kamal Nath, 1997, case regarding leasing public forest land to a private resort. The Supreme Court first applied the doctrine prominently. Intellectuals Forum, Tirupati vs. State of AP, 2006. The High Court used it to prevent commercial quarrying near forest regions. Continual recognition. The doctrine guides court decisions where public land rights, access to natural resources, and preservation are central issues. D. Sustainable development. Background. Our Common Future Report, 1987, also called the Brundtland Report, defined the concept, with further international endorsement at the Rio Summit. Principle meaning, development must meet present needs without compromising the ability of future generations to meet theirs. Requires a balance between economic growth, social needs, and environmental health. Judicial approach in India. Rural Litigation and Entitlement Kendra vs. State of UP, 1985, one of the early cases where the Supreme Court stressed the need for environmental sensitivity during development. Vellore Citizens Forum case and others, the court established environmental concerns as integral to sustainable development. Numerous judgments. The principle now features prominently in judicial reasoning when tackling projects with environmental impacts. Significance. Courts use these principles dynamically, interpreting them according to individual case concerns, often alongside constitutional provisions and specific Indian environmental laws. Let me know if you'd like further detail on any particular principle, a specific case law example, or how these principles interconnect in India's evolving environmental jurisprudence.